So greetings from The Hague. I hope that all of you are doing well. I know it's very difficult times and the news from home hasn't been very good. So I hope you and your family and your friends are all safe. And thank you for inviting me for this session. It's interesting for me as well because the subject, honestly, is a mystery to anybody who's inside the field and outside the field. If you are in international law, there is no point at which you stop looking for a career or you stop looking for new jobs. My name is Vanya, and I'm currently working as a legal officer at the Organization for the Prohibition of Chemical Weapons. I've also previously worked in the chambers of the International Criminal Court. And as far as I understand, this is supposed to be more of a Q&A session. So I will give you an overview of what career prospects in international law actually entails. And then I think the purpose of the talk is to be as useful for your purposes as possible. So if there's anything that I don't know, or if there's a question that I can't answer in the moment, I am very happy to look it up and get back to you. And I'm also very happy to talk to my colleagues if they know better. So feel free to contact me after this as well. So we start off with career prospects in international law is what are the fields that international law entails. So in the immortalized words of the legal profession, honestly, it depends. Because international law by itself is pervasive, and there are a lot of opportunities, but they're quite scattered. I personally am more familiar with the public international law side of things, which is probably what I'm going to focus on. This includes areas like international human rights law, international humanitarian law, international environmental law, and ICL, international criminal law. And then there is also the entire field of private international law, which includes things like international arbitration, international commercial litigation, international intellectual property law, etc. And then you have some organizations which are at the junction of this private and public international law. For instance, right in The Hague, you have the Permanent Court of Arbitration, the PCA, and that works on state disputes related to arbitration. So it's quite like a field that merges these two public and private international law fields. And then you have other organizations which deal with subjects like international administrative law, like the International Labor Organization's Administrative Tribunal. So these are broadly some of the fields that you consider when you look at international law, which is a very broad term. And then where can you work in international law? So I'm sure since all of you must be members or interested in international law or members of the society, which is actually puts you quite forward and quite ahead of a lot of people who get into the field. I know for a fact that I knew nothing about it till I did my LLM and I actually joined it. So most of the things that I came to know about the field were from practice. But in the international law side, you have international courts. So you'd have courts like, in fact, quite a few in The Hague itself, the ICJ, the International Court of Justice, the ICC, the International Criminal Court, the STL, the Special Tribunal for Lebanon, the IRMCT, the International Residual Mechanism for Criminal Tribunals, which is hearing the appeals and the retrials from the ICTY and the ICTR. And then you have the extraordinary chambers in Cambodia. You have the Residual Special Court for Sierra Leone. And now, in fact, there's another development in international criminal law where there's a focus on domestic prosecutions of breaches of international crimes. So you have organizations like the IIIM in Geneva and countries that exercise universal jurisdiction. So they deal a lot with this kind of work. Then other than the international courts, you're going to have international organizations. The secretariats have legal offices, most of them. So you'd have, for instance, the UNOLA, which is the United Nations Office of Legal Affairs in New York. And I work at the Office of the Legal Advisor at the OPCW. And the work in all of these legal advisory sections is quite similar. So when you look at international law, and if you look at the courts and you look at the secretariats, you'd find that within the courts and within the secretariats, the work is quite similar. So if I give you maybe the examples from where I've been, that work is quite transferable to a lot of different organizations and courts. And then other than that, you can also look at NGOs. You'd have Amnesty International, Human Rights Watch, Global Rights Compliance. Then there are private firms that deal with international law, which includes Volterra Fietta in London, for instance. Then most embassies of countries they have an international law portfolio. So they usually require lawyers to deal with their international law portfolios, especially in countries like the Netherlands, which have a proliferation of international organizations. The Indian embassy in the Netherlands, for instance, has the legal advisor who comes quite often to the OPCW and deals with the legal issues that would arise from our relationship with the OPCW. Then there is academia, of course, and that's a huge part of international law. And a lot of these international organizations, they follow the United Nations Common System. So it is governed, the standards and code of conduct and sort of kind of the benefits and the allowances and the conditions of service are quite uniform across these organizations because they're set by this subsidiary body of the United Nations, which is called the International Civil Services Commission. So usually all of these organizations tend to follow the same guidelines. And this is one of the very interesting fields where your steps and your career is not so contingent on what you do. You can be a lawyer, you can be a policy analyst, you can be a scientist, you can be a defense counsel, you can be a tutor, etc. But your pay scales and your grades are set by your step and your grade, which means that there are certain positions within the United Nations Common System, like I am at a position what we call a P2, a professional level 2. So you have positions from P1 to P5 in most organizations. You can have some that have other steps as well. And then D1 and D2, which is director level positions. So it could be the legal advisor of an organization. And the P1 who is a lawyer in an organization and the P1 who is a policy analyst in an organization would probably get the same kind of entitlements and benefits. So that's quite interesting in the field. And then in terms of what the work entails. So first, if we focus on the international courts, then a lot of it depends on the division that you apply for. I can give you the example of the ICC. It has, of course, it has your prosecution, the prosecution division, it has the defense, it has chambers, and I used to work at the chambers of the ICC, that is with the judges. And then, but also at the ICC, you have several other divisions. You have the registry, which deals with a lot of the state relationships of the ICC. So not particularly the case, because it's an independent court, but it would deal with agreements, international agreements. It would deal with staff cases, staff litigation. If people inside the ICC want to sue the court, for instance, at the International Labour Organization's Administrative Tribunal, so they can do that. And then the ICC also has an entire section for victims, because victim participation is quite an innovative thing and a new thing at the ICC. And they have an entire division which deals with victim participation and reparations. So you'd have the legal representatives of victims who would represent the victims in court proceedings. So in prosecution, of course, you would deal with investigation, you would deal with disclosure, you would deal with research and analysis related to evidence gathering, you would deal with filing of motions, writing of trial briefs, and then of course you would also be present in court. So you would argue the actual case that is ongoing in court. And the ICC deals with 4 major international crimes, basically: the crime of genocide, the crimes against humanity, war crimes, and the crime of aggression most recently. And the Defense Council would, of course, have then the defense, and they would also present trial briefs. They would also present briefs and responses and file motions on behalf of their clients. And the chambers would give the decisions on the matters. So in chambers, what we used to do was that we would get several motions from the parties and that you would have to make a ruling on it. You would determine the conduct of proceedings and how a case is to be conducted, which at the ICC is quite an issue because it's a mixture essentially of basically of civil law and of common law jurisdictions. And I know that coming from a common law jurisdiction, it is very, very difficult to get used to civil law because it goes against quite a lot of what we think is normal in a common law jurisdiction, that the way that you do disclosure, the way that you do evidence gathering, and it's very different in the civil law system. So when the Rome Statute, which governs the ICC, tries to merge these systems, it leads to quite an interesting hybrid. And you learn quite a lot about how things that you think of as standard, as common sense, in fact, the conceit of the reasonable man, would be completely unreasonable in the civil system. So that is something when you are in chambers, the conduct of proceedings, which are also determined by the chambers, are very important because that tells you how you are going to look at evidence, how the case is going to be conducted, and that sets the motion for the trial itself. And then the work of the chambers, of course, involves you would assist the judges in court. So you would help with evidence analysis, you would help with evidence review, assist in the drafting of motions, assist in the drafting of judgments. And that's usually the kind of work that an international court would do. And then on the side of international organizations, for instance, like at the OPCW, and like I said, I'm in LAO, the Office of the Legal Advisor. And the kind of work that you have, the major work that you have is treaty interpretation, because most of these organizations have been established by treaties. For instance, the OPCW is the implementing body for the Chemical Weapons Convention. So a lot of questions that states ask us, or we are asked by internal division, relate to how the convention is supposed to be interpreted. When you have verification of chemical weapons destruction, then it has to be in accordance with the convention, and that is what the legal office would look at. But other than that, the work is very, very varied. It can really easily match up to also what maybe a lot of private firms and commercial firms do, that you would be looking at international agreements. It can be voluntary contributions. There can be privileges and immunities agreement. For instance, if you have inspectors on ground in a country who are verifying the destruction of chemical weapons, then they would need to have privileges and immunities in that country. And those are the negotiations that the legal office would carry out. Then you would also represent the organization in staff litigation. So if like an employee of the organization brings a case against it at the International Labour Organization's Administrative Tribunal, the ILO-AT, then you would be drafting and filing the briefs that relate to that litigation. Other than that, you also have a lot of questions that states parties ask about the rules of procedure of the policy-making organs. So you have the Secretariat, which deals with the day-to-day work. And then you have the policy-making organs, which in the case of the OPCW are the Conference of the States Parties and the Executive Council. And for instance, in the UN, it can be the General Assembly. So the functioning of the General Assembly or functioning of the Conference of the States Parties and how to interpret their rules of procedure, how decisions are going to be made, what kind of decisions can be made, that is determined by interpreting the rules of procedure, and we assist states parties a lot with those matters as well. Then we carry out negotiations. I've been on missions to Tunisia on a project dealing with Libya and environmental remediation of chemical weapons program, essentially. So you represent the legal office and a lot of advisory boards. You represent them on missions, especially if you're negotiating with either states or with other international organizations. Like for my case, I was dealing with the United Nations Office for Project Services, the UNOPS. And of course, this work is transferable, but it's also unique because every convention would be unique. So if you were at the International Atomic Energy Agency, you would be dealing with a lot with like the Nuclear Non-Proliferation Treaty and a lot of different treaties like that. And it depends, of course, on the international organization that you work at. But because the mode of interpretation, for instance, the Vienna Convention would remain the same on the law of interpretation of the treaties. So it is quite transferable in that sense. And then you have work at the UN, which also carried out, you have peacekeeping missions, field missions, UN volunteers, and a lot of the work that you would learn at a court anywhere in a domestic court and in a domestic firm. But it's just that you deal with a lot. For instance, W has 193 states parties, so you deal with a lot more states parties in that sense, and you are looking at, but identify separate. So you don't have to so much look at the laws of the national jurisdictions because that is how international law and customary international law has developed. I would like to say, because if you have already been familiar with international law and if you are thinking of a career in it, I'm sure you've already realized that international law has quite a big access problem. The field is very insular, there's self-contained, there's very little information on how to get in. And there is also an over-reliance on unpaid internships. This I'm going to focus on because this is an important aspect of a career in international law, unfortunately, that a lot of the international organizations that people want to work at only offer you at the very basic entry level after graduation, for instance, internships, and most of those internships are unpaid. So if you are interested in working, but what happens also usually that the interns are considered for jobs later, not necessarily, but that becomes an aspect that it could be the case. So in that case, if you are thinking of it, I would encourage you to look at, first try and research on paid internships as much as you can, because it's not really a good system where you have a lot of unpaid internships. I can tell you that the OPCW has slightly paid internships. It's not enough. It maybe covers rent in The Hague, but it's something. So if any of you are interested in the legal office of the OPCW, they have internships that are open from first-year undergrad students in law to master's students. We get people with PhDs. You get like a wide variety of people. So I encourage you to apply to those if that is something that you are interested in. So, and then when you look at internships, the other question that arises is LLMs. Because that is a question a lot of people have, that, oh, do I require an LLM to get into the field? The answer is not necessarily, because it's not a per se requirement. It's not something that you need. But an LLM in international law in particular, and in international courts and organizations in particular, is equivalent to 2 years of work experience. So when I was listing out the job profiles, for instance, to P1 to P5 level, what happens is that P1 means that you require no work experience if you have an LLM. But if you don't have an LLM, then you require 2 years of work experience. Similarly, for P2, if you have an LLM, you require 2 years of work experience, but without an LLM, you require 4 years of work experience. So for a job in an international organization of law, that is a good thing to look at. And especially because internships, if you do them, and this is quite unfortunate that it counts for half the work experience. So if you intern for a year, it will count as 6 months of work experience if you need a job that requires 1 year. So in that case, that is something to keep in mind when you are interning. So if you think, for instance, you can gain a year of work experience with interning, you'd have to work for 2 years to gain that 1 year of experience. But in LLMs, there's also one other thing that you should look at is that a lot of universities, they provide you funding for internships or traineeships after the university. So this is, if that is something you're interested in, it's something to look at while you're choosing your university for an LLM. Because the ICJ, the International Court of Justice, for instance, has 1 year traineeships, and they do not fund it, but they require that it be funded. And so there are quite a few universities that, for instance, would provide you funding for those. And it makes you a viable applicant and makes you a viable candidate. And also, of course, it saves you the monetary burden of having to deal with living in The Hague, which is quite an expensive city, or living in Vienna or New York or somewhere like that. And so when you're looking for an LLM, that is also something you should look at. Regarding the subject, I do not have a public international law background. So is that a requirement? Maybe not. But if you are interested in it, of course, you will take those subjects. I have a commercial law background, which I barely write in. That I have a specialism, I barely write it anymore because it's irrelevant for my field. But if you are interested in the field, those subjects, you can take up basically anything that you want to. You're interested in. It is not going to make you less viable as a candidate for what you do ahead. And you are likely to do better in something that you like and that you are interested in, rather than something you took because you thought it would be useful in some arbitrary context. So internships, LLMs. The third thing I would say that would help you and assist you in making your application stand out is language skills. Because international law is such a vast field, the UN has 6 official languages: English, French, Chinese, Arabic, Russian, and Spanish. So I'm sure a lot of you are already fluent in English, but if you also have another language that you are familiar with, something that you can at least write in an application, you don't have to be proficient. I mean, of course, if you're proficient, that's much better, but even if you aren't, if you can write in, automatically stands out. And if that language is French, even more so, because French is the working language for a lot of organizations. OPCW, the working language is English, but at the ICC, the working languages are English and French. And they have a lot of cases that deal with French-speaking countries. So you have a lot of evidence that it's in French. And so if you can't speak it, or if you are fluent in it, that will really help your application. So I would suggest that if this is something that you really consider, that you're really considering going into, just starting off a course or just being able to reach a basically even level of proficiency to be able to write in your application already gives you maybe double the opportunities. Then the fourth thing is domestic practice. This is debatable. I do not have domestic practice either. I straight away went for an internship at the ICC or at the OPCW, then got a job in both the places. So it's not necessary, but every single colleague, because I was talking to my colleagues about this talk and I asked them what they think are the factors that you would want to inform students about in this context, and almost everybody said domestic practice. And the reason for that is because when you enter the international law domain, you are already working, they will not teach you the basics. You will not be learning how to draft, you will not be learning how to file, you will not be learning all of the basic things that you might learn in a firm or that you might learn in your first 2-3 years of domestic practice. You would be learning all the administrative things, how to get a motion filed, etc. And even though the system differs, obviously, because it is based on their internal rules and regulations, it's the ability that is also honed through practice. So domestic practice is something that is also favorably looked upon in when you apply for an international job. And this is also because there are very few entry-level positions in a lot of these organizations and courts. So when you come in and you have no experience, then either you do 4 years of internships, in which case it's quite possible that after 4 years you might be considered unemployed. There'll be a lot of questions about why you did not get a job in 4 years. But if you already have some experience in a domestic jurisdiction, if you have maybe a year or 2 years, you've already met the minimum eligibility requirement to be able to apply. And by itself, because then you don't have to wait and like do a lot of unpaid internships and hope to get a job, but you are automatically at least eligible. And that's, of course, the first step to actually getting a job in the field. The, I think, fifth thing is, I would say, publications and drafting work. Good drafting skills are always going to make you stand out in any kind of work that you do, because it's very important for a lot of these organizations. If you're not at an international court, you're not going to be arguing cases per se, but you are drafting legal opinions, drafting advice, drafting legal interpretation memos, etc. all the time. So if you can show that you have drafting skills, and if you have publications that people can read to judge your drafting skills, that is very, very helpful in an application. And a lot of the people in these fields, a lot of the lawyers who are international lawyers are very academic as well. They publish a lot, they teach a lot. So they're always very impressed if you have also already at this stage showed an interest in that kind of work. Then the sixth thing I would say is field experience. The Hague is not the field per se. So most people would come to the Hague after they already have go to the countries where you have peacekeeping missions or you have UN volunteers, etc. Because what that does is it's very rewarding. From what I've heard, when I was in Tunisia and the UN Helps project officers there and the lawyers there said that their experience had been extremely rewarding, because you're working in a very small team, you're dealing with almost every issue that comes into that team, and then you are working on ground on the issues that you are going to be dealing with in international law. Because sometimes in The Hague it does feel like a bubble, that you listen to witness accounts and victims accounts of very awful, horrible, terrible crimes, and from some that happened years ago, but you have no idea of the place unless you are an investigator and you have actually been there. You would not know it as well. So this is something that, this is a problem that they do face. So fieldwork is useful, and it's also useful is because it is a slightly less competitive. I mean, a lot of these organizations, you would always have thousands of very qualified applicants. Thousands doesn't sound like a big number if you come from India, but it is thousands of absolutely top of their own fields. So it is quite competitive. And fieldwork is equally competitive, but there is more hardship involved. So there is slightly less competition in that sense. And then maybe the eighth thing I would say is look for organizations to apply to where India is a member state. Because for instance, at the ICC, India is not a member state. And when you apply to it, there is going to be, you are going to have a competitive disadvantage because it is going to prefer the people from the states which fund it. So you do have certain numbers that are allocated according to funding. You there, I was working at the ICC, so that it doesn't stop you, but it does disadvantage you. While if India is a member state, the chances are that they do need geographical representation as well, which is really important in international organizations. They're trying to increase their geographical representation, and then it makes you a good candidate in that as well, that you're highly qualified and you're from a jurisdiction that is underrepresented. Then the last thing that I would say is that it would be really good to get a bar qualification or a qualification in any jurisdiction. This is because that gives us a competitive advantage in international law, particularly because a lot of jurisdictions have really difficult bar qualifications that you would not only have to give an exam, you would also have to go to bar school. You would also have to work at a firm for 3 years before you can be considered a practicing lawyer or an advocate. And we are lucky in the sense that we have the bar exam. So if you are bar qualified, that by itself sets your application apart from a lot of other people's. These are like a basic overview of help you. And I would also say that whatever you do in this field, you have to be audacious. Just apply. You apply for things that you are underqualified for. You apply for things that you are ineligible for, because you really never know. And I can give you an example at the ICC. I finished my internship, and that was my first internship for 6 months. So you can imagine I had 3 months of work experience according to the international law regime. They had a P2 position open, which requires 2 years of work experience, and applied for that. I was shortlisted for an interview. They interviewed me, and then later, after a month, I asked about it, and they said, "Oh, we're sorry, you're ineligible for it. You don't have the work experience." And I argued, well, eligibility should be first step. That's what you determine before you call for an interview. And they said that there had been some mix-up maybe, but it was unfortunate. And they told me that my interview had gone fine, but I was not eligible because of the work requirement. That was that. But then 3 months later, the ICC opened up a P1 position, which was, require no work experience if you have an LLM, which I did. So I applied for that. And one of the interviewees was the same as who had been there for my P2 interview. So I'm not sure. I cannot assess how that. But the thing is that then he had 2 interviews that I had given to be able to choose from, essentially, even if one of them had been a mistake. So it can help you, because a lot of times that I have been on the recruitment side of things. I have recruited for internships. I have recruited for other positions as well. And I know that we look very closely at the applications. And we do usually call for an interview as well. And we would pick applicants who, even if they don't have too much experience, etc., depending on their applications, we would pick applications where we're like, oh, we're not sure you meet it, but if the application is good, you could be listed regardless. That is something that I would encourage you to do. And the other thing I would encourage you to do is that if you know people, especially academics or lawyers, etc., whose work you admire, or the people you like, reach out to them. My boss, who is the legal advisor, in fact, currently the acting legal advisor of the OPCW, it's a 10-year organization, so everybody leaves the organization after 7 years. So people keep applying for jobs all the time. So even now, they would reach out to people whose organizations you're applying in. It's a balancing act. You don't want to come across as you don't want the other people to dismiss your application or feel annoyed that, oh, I don't have time to do this or something. You'd also be surprised by how many people are willing to do that. So that is something that I would say. I would wish you really the best of luck. I hope that a lot of you really do want a career in this field, because it's true, we are underrepresented. There is not much information. There's not many people working in the field that I know of. I'm sure there are in other places as well, but in The Hague, I'm not aware of many. So I think it's great that you're already interested in the subject and that you can go forward and actually work in the field. And I'm sure you're much more qualified than when I started out. So that's something you already have in your favor. That's all I have to say on that issue, and I'm happy with any questions or anything that anybody might have.
Thank you so much, Vanya. I think that was really something we heard things we possibly wouldn't normally hear about, and I think it was a great perspective. We have a few questions regarding LLM, especially about, so if you could just discuss in brief, like in very brief about what the application process entails and what are few things that stand out in the application. And secondly, about why you chose Cambridge or where all did you apply and how did you make the decision of choosing Cambridge?
Yeah, so for the LLM process, in the application process, what I would say is that I'm sure you already know this, but you always cater to what the application is asking for. I am not certain if this is true for universities as well, but I have heard it in organizations that some of them have algorithms which look for the words that they have used in the application. So, for instance, if somebody is asking for a certain skill set, or if somebody is asking for a certain experience, use the words that they have used before you start elaborating. Because then sometimes it's a check mark. Nobody has time to look through very carefully. Even for recruitment applications, even at the highest positions, there's only a limited amount of time that you can spend on an application. When you're trying to stand out, structure your application always according to the questions asked. I mean, done that are absolutely amazing and that you really want to write, but also to put them later. Always focus your application first on what would assist you most in terms of what is asked. So what the process involved was that you have to be prepared with documentation beforehand. Because, and I know it's really difficult for the students graduating this year. I know that is a really difficult, I don't even know how, I'm sure Nalsar is doing better than a lot of other universities are doing in this matter. But if you are prepared with your documentation beforehand, then you're saved all the grief at the end when something goes wrong, or you need an extra some week or something to prepare something. And then the application deadline is closed and you're very stressed out. So all of that can be avoided if you look at what documentation is required and prepare that, especially things like your professors who have to give you your letters of recommendation. So choose those professors beforehand. Always choose professors who really know what your work is, what your work ethic is, and you have worked with. Because a lot of people choose people who are famous in their fields, which might be helpful, but not necessarily, because they definitely would not be able to write about you with the same level of depth and knowledge as somebody who has taught you, even if they're not renowned in their field. And when recruiters or when or admissions recruitment basically looks at all these applications, they pay a lot of attention to the SOPs. There's a lot of, on the letters of recommendation. There's a lot of emphasis that is put on that. And regarding the SOPs, this you have to know for yourself in the sense that would you like it to be reviewed by a lot of people? Would you like to ask somebody who is maybe in recruitment, ask somebody or some of your friends who have applied, etc.? I did not. I usually write applications and send them by myself. Sometimes I'm successful, sometimes I'm unsuccessful. I'm also always last minute, which is not a good thing. So I'm telling you to not do some of the things that I do, really. So in SOPs, if you need a skeletal format, because of course you cannot write completely new things. Your achievements are not going to change from one application to the next. So make a skeletal format, add in most of the things that you want should be in there that you think will make you stand out. And then on top of that, you look specifically and structured specifically according to the applications. I know that they had an application process where they asked you 3 questions. What would you like to study essentially, and why, and how your past experience and your past academics would make you a good candidate for that. Second had something to do with where do you see yourself 5 years down the line. And so the questions are quite generic usually. There might be some universities that are very focused that ask you very specific questions, but usually I think universities are trying to get an overall view of you as a person, because they know like people come in, they change their thesis topics, they change like anything that in the beginning, the subjects they could have chosen, they change their fields. All of that is acceptable. But if you already have an interest, that you can demonstrate that. Look up the courses, and specifically the course that you want to take and the university offers. So show some knowledge about that course. you can just add a few words in your SOP, which shows that you have researched into it. You would be surprised by how many people don't do that at all. So it seems like a basic thing. It seems like, well, of course, if you're going to apply to university, and of course you would look up what it entails, but not necessarily, because people apply to universities without caring about what course they take. So if you do have something you're interested in, and you're not bound by it at all, you can always change it. But if there is something you're interested in, that could also be reflected. Try and tie up. It doesn't matter how many internships you've previously done. It's not, I mean, people come in with very different credentials, very different requirements, etc. So you always have a chance, which is why it's more about how you frame it, what you got out of it, how does it tie into what they want. So it's connecting yourself with the university and what they want, essentially. You just frame all your achievements in a certain way. That would help, particularly your application in that sense. The other, LORs, SOPs, documentation, getting your final clearance. Cambridge also requires the English language requirement. I didn't take the IELTS or anything like that. So all the universities that I applied to, I asked for a waiver of the English language requirement based on the fact that I had completed my entire education in English and that I had degree previously in English literature, and that all my education essentially had been in English. And I did get waivers from quite a few universities. But Cambridge still requires you to take an exam, but then it would be a Cambridge exam. You can just give it online, and they also call you for a language test, but you don't have to necessarily take the IELTS in that sense. This is what I can think of for the application. Why did I choose Cambridge? When I was applying for an LLM, I wasn't at all very sure of what I wanted to do, which is why I applied for the LLM. I definitely did not think of international law at all or anything of the sort. So when I was applying for the LLM, I was trying to debate between, should I maybe qualify practice domestically or apply for an LLM immediately? A lot of my friends were applying, so I thought maybe this is a good stage at least to try and apply, which I did. And then it was, I'm sorry, my laptop is almost getting started. So I did apply. Cambridge was the first application, and I wasn't sure, but I was like, okay, even if I'm applying this year, apply to all the universities that you applied to. I wasn't planning on applying to Cambridge. I really didn't have a structure. I didn't have my SOP and things, so I thought, okay, maybe I'll let this go. I wasn't sure I'd get in anyway, and then I'd focus on others which were later. But as a friend of mine told me that if you're applying this year, just apply to everything that you want to apply to. There's no reason, even if you don't get it, you will at least have a structure by that. So I applied to Cambridge. I applied to Oxford. I applied to, I think, UCL, King's, Queen's, a lot of colleges here. I applied to, I think in the US, I applied to, because a lot of them require work experience, and I had no work experience. So I couldn't apply to Columbia, Stanford, etc. And I applied to UCLA, and I applied to Berkeley. I did not get in Oxford, and I got in all of the rest of them. And I chose Cambridge because it was much cheaper than any American university. American universities are expensive. So that was really one of the, it's very well known. It's quite well known. It's one of the top in its field, and it will always come top in most rankings, but it's also much cheaper. And secondly, it's also cheaper than the London universities because you live outside London. That makes a huge difference to your rent, because London universities like UCL, LSE, etc. I'm sure the tuition fees are about the same for all of them, the UK universities, but the living expenses differ quite significantly. So that was also a factor that I took into account. But if I look at it retrospectively, Cambridge was a good choice, but it is also not, you wouldn't have as many opportunities from Cambridge, what I was suggesting that you look at in an LLM. So I know some schools like NYU, for instance, offer you that funding for maybe an ICJ traineeship or something. But it's necessary that you would get the same at Cambridge. So if you look at American universities, they are very expensive, or even other universities. If you look at European universities, I know there's a lot of good ones for international law, like right here. It's very well known. It's right next to a bunch of international organizations. So a lot of their students come for internships easily. They have professors who know the field very, very well. Around the place. factor to take into account when you are LLM.
Yeah, okay. So I think another question that we had was also with respect to applications. And like there are a few people who have already done a lot of international moves during their
Yeah.
5 years of law school. So is that something that's positively looked upon, or like how could they use that experience while applying?
I think it would be positively looked upon, for sure. I haven't done international moods, but I have prepared international. For the ICC, I've helped with the ICC mood. For the Tellers International mood last year. So I think it is something that you show, like that you would put in an application if it is something that is you've done, you've scored well in. Like I'm sure it'll be looked upon favorably, and you can again. It's not only what you've done, but how you tie it in with what you want to do. So you can see what preparing for that international law will teach you. Not only thing, but the amount of work that went into the preparations that you had to draft an entire, essentially a trial brief, that you had to argue essentially before a tribunal or court or like adjacent. So if those things that you show, like, these are the skills I picked up from it, and these are the skills that are going to be helpful for me, so that helps you stand out more, because then it is really directly correlatable with what you want to do. And you say like, and some of the international law questions and international moods, I know for a fact that they're much, much more difficult than anything that you would face in an actual court. A lot of people who work in international courts would be able to answer the questions that are posed in international moods. I mean, even when they're being prepared and everything, the number of issues involved, the complexity of the issues involved is very high. So it is something to be proud of. It is extremely, like, it is an achievement. It is something very helpful, but always tie it in. Always say what you learned from it as well, and not only that you did it.
Yeah, I think that makes sense. So, like a follow-up question to that would be that if somebody is not very interested in doing moots or let's say ADR competitions, so would that be something that will adversely affect the LLM application, or it's completely fine if you make up the other stuff?
Not at all. I mean, I would not say so. I only, I can't be sure. But also, I think a lot of my friends who did LLMs in lots of different places, no, I mean, I'm sure it looked upon favorably if you have done it. But even if you haven't, it's not at all something that will hold you back or hold your application back. If you have other things that make up for it, if you have publications, if you have internship experience, and you don't need a lot of any of these things, you just need enough to be able to like make a good case for yourself, essentially. So you don't have to go crazy doing internships just because you assume that it will get you somewhere. You can do 3, you can do 2, and if you say, this is how much I did in it, that'll help you more. So if you don't do international moots, or if you haven't done a moot at all, I think that's absolutely fine. I've been judges for moots and I've never done them. So really, I think it'll be absolutely fine. You don't have to worry about that.
Yeah, thank you so much. And I think there's just one more question with respect to LLMs in Cambridge in specific. So could you just tell a little bit more about your time at Cambridge, and what was the course structure, and what was like how much independence did you have in choosing the courses that you could pick up, and what all could possibly they do within their LLM?
So at Cambridge, you have lots of you probably have like 42 courses or something that you can take up in your LLM, and you are free to take up anything. Of course, if the course is being offered that year, you can take up anything. If you do take up just anything, you would get a general specialism. Like, you wouldn't get a specialism, you would get an LLM. But you have certain courses that have specialisms attached. Some of them, you can only get one. Some of them have multiple attached, but you can only get one. And you can choose which one if you take certain courses related to that specialism. So, for instance, international intellectual property fits within an IP specialism as well as an international law specialism. And there'd be something like international criminal law, which would be an international, so you need to take 4 subjects at Cambridge. And if 3 of those correspond to a specialism, you can get that. My courses particularly were they were competition law intellectual property, law and information. And international criminal law was just something I took because I already had a bunch of like these other commercial, which gave me a commercial specialism. And I could have also applied for an intellectual property specialism, because one of them, that is. So if you don't apply for one, they give you the one that starts with the alphabet from the top, which means because I didn't specify what I wanted, they gave me commercial. C comes before I. So that's how that specialism works. But so you can choose whatever courses, but if you want a specialism, you'd have to at least take 3 courses of that specialism. And when you do take 3 courses of the specialism, it's always good to try something else for the 4th course. Like, don't also take something that corresponds to the same specialism, because then you get a better idea of what you might like. I did 1 paper in international criminal law, but I was told by my director of studies that, I was planning on taking another course, and he told me, this in Cambridge are known for international law. I think you'd enjoy it. You can try it. So I was like, okay, let's try this. And that ended up really being beneficial for me. In terms of other things that you need to look at is that if you want to do, Cambridge has a system that is exam-based, pretty much like a lot of Indian universities. You have 3-hour exams for most courses, but they allow you to do 1 thesis out of the 4 subjects that you have. But the thesis topics have to be given in almost immediately. You go in and within the month, you have to give a kind of a brief and your topic. I'm not sure if you can change it later. I think you can, but you do have to give it in. You do have to make a case for your thesis. So if you want to do that, if you don't want to write the 3-hour paper for 1 paper and would rather do a thesis, which is a really good idea. I didn't do that, but I think I wish I had, because I think that is, you can always publish it later. There's a lot you can do with a thesis. So they require you to do that right at the outset. So if you're thinking of Cambridge, that is something that maybe you should also look into. That is there any of the subjects that you're interested in that you would also want to write a thesis for? Then you won't have to give the 3-hour exam for it and can instead do the thesis. Other considerations were the Cambridge experience is very good. You do have a lot of people who are top of their field, essentially. They're professionals, they're practitioners, they're people who've been in their fields for a very long time. I know my law and information professors, for instance, were helping draft the GDPR, which is the privacy law regulation that the EU is coming into the EU now. I did it in 2015-16, and now in 2018-19, it came into force. So you have people who work really on the subjects that you're going to be studying. As with any other university, you're going to have just some classes that are going to be much better than others. Because you are a good practitioner, because you are a good lawyer, does not necessarily make you a good teacher. So you always have a divide there. You will never have an experience that is absolutely brilliant. You recommend it to everybody, but you also learn a lot of things from people who are doing it, which is a good way to learn. Other than that, it's a great personal experience, because Cambridge is they teach you a lot about how to conduct yourself in meetings. They teach you a lot about, if you have been drinking at a graduate seminar, can you still sound coherent and sound intelligent? That doesn't sound like something that a lot of people think of, but once you are in the field and things, and you do have all of these events and gatherings and things, so you always have to know, how is it going to be most beneficial to you? How can you conduct yourself? Talk to the people that you most want to talk to. So that is something that Cambridge it never teaches you those things, because they have so many formal halls. They have so many things like graduate suppers and talks from people, and they have so many events and recruiters coming in. So that's a great experience. And personally, you have it's a really good time. You can focus a lot on studying, and you can focus a lot on trying to get a first or trying to get the highest grades, etc. Or you can just balance it out, and you can have a really good time and also be able to, get a degree that is going to be beneficial to you in the future. The name, it's true, is beneficial. That nobody even looks at mostly at what you studied in the field. They're not very concerned about how good your professors were, etc. But there is a per se presumption that, if you went to Cambridge, you must have done something. I'm not saying it's rebuttable, absolutely. It's not even true. It might not even be true, honestly, but it's something that a lot of people just maybe because of the ranking and think it's been ingrained that, you might be smart, or you might know what you're talking about. Again, that is not necessarily true. I have experience.
Okay, so I think there's another question with respect to internships international, especially when we are within our 5 years law school.
Yeah.
So firstly, how should we be approaching, and like what are the opportunities which you think would be worth looking out for? And especially in times of COVID, where like there have been travel restrictions, and in general there have been lesser opportunities. So how could people deal with that? I think that would be something that would be useful for everyone.
I think on this matters because a lot of these internships are for a specified period of time. So it would be maybe a minimum of 3 months, 6 months, sometimes a year. So it is a bit difficult to do when you're still working, when you're still in your undergrad, because either you need some time off, which you might get the summer holiday, so you can do a 3 month internship, a full 3 month one, and then that would be useful. The OPCW, for instance, I think you can apply for that. You can say, though, I would like to work for 3 months. I'm not sure if that would be one of the considerations they would take into account. They might, because even for them, they prefer continuity. So if you have somebody for 6 months, it might be better for them than if you have somebody for 3 months. But we have had people for 3 months. I've had a lawyer from Australia, and she was in her first year of law school, and she interned for 3 months, and that was fine with us. So we do like to give opportunities as well, but you would have to think of the time period. Are you going to be able to commit that time period? Because it's a 9 to 5 job. 9 to 5 is minimum. It is a job basically. When you are doing an internship, you are working. You are absolutely 100% a part of the team. And depending on the organization you apply to, some of them have just very small legal teams. So you rely a lot on people who do internships, and the interns, they're very, very helpful. They're fully fledged members of the team. So if you want to work in it, maybe think of the time commitment. Second, usually you would have it in the place that you're at. But with COVID, I'm sure there have been changes. Not significantly that I am aware of currently, but that's also probably because they're getting used to this system. And it is quite possible, in fact, that going forward, a lot of international organizations might have remote, that they would rely on remote meetings more, that they wouldn't require you to be on field. I think in the United Nations especially, that is already happening even with staff. I know that the OPCW and the ICC, they are not remotely onboarding yet. They expect the people to be here physically, even if you kind of go in remotely. So it's not the best system yet, but I think that's because it's still developing. The more systems develop for working from home, we had no working from home capacity when COVID hit. So it was quite a task to get laptops for everybody, especially because if you deal with a lot of confidential information, that's always one of the concerns. You can't work on any laptop. You would have to have the security management systems. You would have to have, be sure that the evidence is safe, etc., things like that. So remote working is, in some organizations, it's hard, depending on how hands-on they are. But if you have research work, maybe in the International Bar Association, which is also in the Peace Palace, if it's an organization that has a lot of research work, they might be happy to have people, not have people come in and not have to spend resources on that. But it is something that I think you'd have to look into and research because it's still developing. There's no coherent or clear answer to that, but I'm sure it is developing, and I'm sure that this is going to be a thing in the future. So keep a lookout.
Okay, so I think we'll just take 2-3 more questions and then we can just wrap it up. One more question that we had is, once people have already begun their career in international and have worked for a few years, how easy or difficult would you say is for them to switch to another career field? Let's say they want to do something else, they want to work something like not broadly in the field of international law, but something else. So how easy or difficult would you characterize that switch might possibly be?
People, because the international law field is so that you always have to keep applying, there's very little job security, and that's something you should consider also when you consider career in it, that it is very unstable. It is just there's lots of short-term contracts, but it is not that you have contract for life once you get in. You might have it for 2 years, then you have to look again, have it for another 2 years, if you're lucky, that is, and then look again. So it's always constantly looking. So people do move out quite a lot. In fact, staying in international law is quite hard, but people do move out a lot. And for this reason, also domestic practice is very important. Because if your only experience has been international law, you still have transferable skills. I mean, you still negotiate like multi-million-dollar contracts constantly, like almost every day. you would do that. So you do have a lot of skills. You draft a lot of contracts. You deal a lot with litigation. So you have the basic transferable skills that you would need for any kind of legal job. It's not an issue. And also people sometimes, I know that when I was home and I was wondering about the same question, I was asking, it was after I'd finished my job at the ICC and I had not yet got the position at the OPCW. So I was asking around. It was the Cambridge and Oxford Law Society. There's a society in India. So that, I was wondering the same thing. I was like, is it possible even to switch? Like, I have no experience in this field. And then I was told by a lot of people that it would still be looked favorably upon that you worked at, an international organization or international court. But domestic experience would help you also say that I have direct skills that can be applied immediately. I don't have to learn on the job and stuff. So for that, if you do think that that you might want to try anytime, you might want to try something different, it would really be helpful if you had domestic experience first, because it is easier to switch into the international law than it is to switch out of it, because you work in like such different matters. The laws governing it are so different that even if you have transferable legal skills, it might be something that somebody might think that, you would prefer somebody who knows how to file a brief, even if you filed before the ICC something. So yeah, I would suggest that if that's something, then domestic practice is really important. But if you do want to switch out, there are absolutely several opportunities for that. I mean, there's nothing stopping you. The skills are very transferable. You just have to make a good enough argument for it, do really well in your interviews. It's just the recruitment process of it.
I think that's really helpful, because that might be a concern for many people who are thinking if international law is the right fit for them or not.
Mm-hmm.
So I think we just have two more questions, and they're more generic and not really career related, but more international law related. And I think the first is something that many people have been talking about recently, and the effect of pandemic on the working of international law organizations, especially in context of how there is an emerging protectionist trend in multiple countries. So do you think that the influence of international law might be adversely affected because of the same?
This is a really good question, because we are dealing with it live every single day. There's been a shift in global polity. There's been a lot of discussion about whether the norms of international law, the idea of international law in general, is eroding. Because the nationalism is becoming much more prevalent, rather than like this international sovereignty of states coming together, meeting and negotiating and diplomacy. There's much more protection of states and intrastate interest rather than interstate interest. So, and COVID does not help with that, particularly in relation to travel restrictions. Things like that, where travel used to be easy. It's easier to apply and get to places, especially when you're always traveling, when you're always on missions. Half our missions at the OPCW, for instance, some of them have had to be paused, of course, because of this. There's lots of jobs that have been lost, lots of opportunities that have been lost. And second, you remember that international organizations are funded by member states. So whatever is going on in the member states, whatever their financial position is, that is only how much ESS contributions are going to be, what the status of the international organization is going to be. So if you have withdrawals, or if you have something, it significantly affects the work of the organization. So in that regard, because there has been maybe, at least like the norms they're not weakening per se. I mean, I wouldn't say that. International justice is still what stands, in fact, and teaches you, COVID has taught us how globalized the world really is. That no longer can you be isolated, no longer can you pretend to be isolated, no longer can you hope to be isolated. We just are interconnected. And international law are the rules that govern this interconnectedness. So even when there is a move towards more national interests, international law is still what would set the standards for those national interests. You would still say that as countries, you're not free to do whatever you want to your citizens. You are not free to behave in an international sphere as you would wish, regardless of how powerful you might be or how not powerful you might be. Because international law is based on the basis of sovereignty of states, that all of them, regardless of their people, regardless of how much their GDP might be, etc., would have one vote within the organization. That you would be able to contribute equally in the work and develop the norms equally. Does it happen in practice is debatable, but that is what the intention is. So it has made day-to-day functioning very difficult. In working from home, like I said, we didn't have the capacity for it. A lot of the work can't be carried out from home because you really have to be on ground. If it's the destruction of chemical weapons, we verify the destruction of chemical weapons. You can't do that from home. You would have to be on ground. You would have to actually test and see and have scientists on ground and have inspectors on ground and a lot of people. If you want to negotiate with different people. Now, of course, we're moving towards more of an online negotiation technique, but still negotiation involves certain skills as well. There's a lot of body language. There's a lot of negotiation that works in the back doors in track 2 negotiations. So it is getting difficult, but it's also made you realize that this is what is important, like the WHO, for instance. All of us are part of some legal advisory sections, which involves most of these international organizations. So we do get a lot of information from WHO and how they're functioning and things. So like when you realize that you have an international body that is reputable, that a lot of people at least can believe in, that you believe the information coming out of, and that is very important in an age of disinformation and misinformation, that you have to set a certain standard of rights. So things are very difficult. It's difficult to tell how they will evolve either, whether there's going to be a loss in jobs. And that's one of the major concerns that a lot of people have, especially if there is, as there's been a lot of talk about, a recession and how that affects the member states, how that affects their contributions, how that then affects job prospects. But because of that, and a lot of people have also had to go home, also like maybe leave their job because there's also other considerations now, family and things that you have to think about more. A lot of people who left because they realized that cross-border transport is getting difficult, so you might not even be able to see your family. How long it'll last is difficult to tell right now. And because this is all developing, it's also difficult to tell, but it also tells you a lot about state responsibility, how states have to deal with information or something like this happens. What are the state responsibility in this case? How are they set? So when the WHO sets standards, or you can go to the ICJ in some cases, people have already been debating that as well in the international sphere. So COVID has made things difficult for everyone. Particularly internationally, hasn't been easy. You still have a lot of protection because once you are in the service, you have the kind of protections that you would get in maybe a domestic civil service. Because in fact, the standard is set by, like I said, the International Civil Services Commission, which is why my position is titled not lawyer, but legal officer. So you are an officer of the court, or you're an officer for that. It's like being a domestic civil servant. So you have a lot of protections. Once you're in, it's not that difficult to just tell you, oh, please leave, we don't have the money for you. They have to find the money in some way. So if you're in the field, it's really good. But if you are in one of the vulnerable positions, like an intern or a consultant where you don't have the full rights of a staff member, then it can be much more difficult.
Okay, I think we just wrap up with one more question that's here, and that's also with respect to ICC in general. So I think in the recent past few years, there have been questions raised on the legitimacy of ICC, whether it's with respect to, let's say people are saying that there's an African bias on the basis of the cases that the court is considering, or if there are a few powerful countries like the USA and a few others who have somehow refused to recognize the court's authority. And there have been criticism to ICC on these lines. So would you think that this is something that's a fair criticism, and how could that possibly be responded to?
Interesting. I'm not even sure I can answer that question in terms of having worked there because, they do have limitations. But what I can tell you are the criticisms. I think the criticisms need to be made specifically because a lot of people are not very familiar with international law as a field or the international courts or their functioning. And so there's a lot that can happen where there's not much information available, so nobody says anything. But so it's good that people criticize. But once you are in it, so for instance, the African bias, a lot of times that gets refuted is by saying that, well, a lot of the countries that are at the ICC have been self-referred. So it has been the African countries themselves, a lot of them, who have referred the cases to the court, because that is one of the means in which you can get a case in the court. And once you have a referral in the court, they do not look at who referred it. At least it's not within their mandate. The mandate is to analyze and investigate the situation. So if you have a time period in which an alleged war crime was committed or genocide was committed, then you would look at the entire situation. You wouldn't look at, oh, it was this government that referred this situation, so we look at the opposition. You would look at the entire situation and then ascribe individual criminal responsibility on the basis of the entire situation and the investigation of the entire situation. And so in terms of, is there a bias, or are there powerful states? I mean, the US is a powerful state for sure. And there is like an entire article of the ICC in the Rome Statute, which deals with the US as well. So, but when you had a case like Afghanistan, for instance, the different chambers have said different things. So is the court itself that influenced? It's difficult to state, because it is going through hardship because of course, like there are questions raised about sanctions and things. So it was a difficult time for the court, I'm sure. Like I'm not at the ICC anymore, so I can't speak on their behalf, but I can imagine that it was not easy. But regardless, there were steps that were taken. I mean, that they did not actually bow down to pressure, so to speak, because the investigation was going forward. So it really depends, and that is something that you would have to always look at, for any criticism, that are they following the mandate that has been given from somewhere else? And it's easy to tell. So if you are following the ICC and you read through judgments, read through motions filed, read through all of these, like through pre-trial hearings and things, it then is easier to tell, or is it that a certain mandate is being followed, or is it that they're still independent regardless of the pressures? And of course, you have powerful states with not only the United States, but India is not a member state, Russia is not a member state, China is not a member state. These are all really big and powerful countries, and they have similar interests in some, for instance, the OPCW, which doesn't deal with ICL, but it deals with use of chemical weapons, which under the Rome Statute is a war crime. So if there has been an international armed conflict or something, or there has been a use of chemical weapons under Article 8 of the Rome Statute, so that is something that they will always look at. And these states parties are member states to this organization. So the international regime is very connected. So when the ICC is one body, it's the permanent court, which is why it requires a lot of support, because if it is supposed to be the permanent court, then you wouldn't have the ad hoc tribunals and the hybrid courts anymore. This is where all of the issues that are related to international law that fall within its jurisdiction should go. But of course, the United Nations Security Council has members who have veto powers, who are not members of the ICC. So what cases actually go to the ICC through a UN referral or through the prosecution starting cases? It really depends on the case itself. I think criticisms are always fair, because there have been a lot of African cases. The African Union has also said a lot of things on it. But if you look at the actual way in how the cases came in, then it becomes a bit more complex, because it becomes a bit more difficult to say, oh, should you stop states self-referring, or can you ask states to self-refer or not? Because they do have a lot of other investigations ongoing, but they haven't reached the stage of asking for the opening of an investigation, for instance, from the pretrial chamber.
I think that would be all with respect to the questions, and we've already exceeded the time. So it's fine if we wrap it up here. Thank you so much. I'm sure that this will be a really beneficial and helpful session for everyone who was attending. And like, we got to hear and understand things that possibly were available to most of the people at this stage during law school. So I think it's been a really learning experience. And I would like to thank you on behalf of NSIL. Thank you so much for your time.
Thank you. Thank you for inviting me. I'm very happy to be here. And again, if you have more questions, always feel free to reach out. So
definitely.